Good afternoon, everybody, and thank you for joining us for today's discussion. We have a few more folks joining us. We're letting some more participants in, and as we do, I'm going to go ahead and get us started. So today's session is on the Chauvin verdict in police reform, a conversation with attorney Riley Ross. Before we begin, special thanks to the Office of Diversity and Community Engagement, our General Counsel's Office, and the Office of Student Engagement and Inclusion for helping us put today's program on. In response to the Chauvin verdict being read 2 weeks ago, a coalition of UHart staff, students, faculty, alumni, affinity groups of color, and other campus partners came together to prepare our community for what might unfold. Our intent was simple. It was to provide spaces where meaningful dialogue could take place with the purpose of taking action and creating inclusive change both on and off our campus. In 2 short weeks, several sessions, programs were developed to give our community an opportunity to engage in dialogue around police reform, the trial, race, injustice, and campus climate. As a result, we were able to share our own PS reform efforts. Student staff participated in the NAACP Knowing Your Rights session. Our student affinity multicultural leaders held open sessions with students to discuss campus climate. And our CAPS team provided affinity spaces for Black, Latinx students to gather, share, and process the recent violence and the trial. Today's program represents the culmination of those sessions as we shift our lens towards action and processing what this verdict could mean for our judicial system and our country moving forward. The Chauvin verdict of guilty represents a potential watershed moment in the longstanding fight to hold law enforcement accountable for the violence and abuse of power perpetrated against marginalized populations. In some ways, the verdict has penetrated the venerable blue wall that has allowed police to operate with relative impunity. It has validated the countless lived experiences and narratives of Black and brown people that have been mistreated, abused, and have died at the hands of law enforcement, to only have their stories disregarded by a system never really designed with their best interests in mind. In other ways, the murder of George Floyd, the trial, and verdict illuminated to the world America's ongoing battle with race and racism, our inequitable criminal justice system, and the power of the collective voice to demand change and justice. As people, they can no longer take us watching 8 minutes and 45 seconds to act. We must demand more of each other, our systems, and our leaders if we are to make meaningful systemic change. To understand what this verdict may mean for future trials, police accountability, and overall police reform, it is my honor to introduce today's moderator and speaker. Helping to moderate today's discussion is our own Nia Mills. Nia is a junior here at the University of Hartford. She's majoring in politics and government with a minor in Africana Studies. She's the current president of the Black Law Student Association on campus and is the current treasurer for UHart's NAACP chapter. She's also a senior RA for the university, as well as a member of our women's track and field team on campus. Now for our guest speaker. Riley Ross III, attorney Riley Ross is a law partner at the firm Mincy, Fitzpatrick and Ross in Philadelphia. He is highly skilled and experienced in the areas of federal criminal law, white collar criminal defense, civil rights litigation, employment discrimination, and general civil litigation. His previous positions included private practice at Ross Legal Practice, LLC, at litigation powerhouse William and Conley in Washington, D.C., and Drinker Biddle and Reith at Tucker and Law Group in Philadelphia, and as the Assistant Federal Public Defender in Norfolk, Virginia. Attorney Ross received his bachelor's in psychology from Longwood College, a master's in experimental psychology from Western Kentucky University, and a JD from the University of Virginia. After law school, Mr. Ross clerked for the Honorable James C. Kacharis, U.S. District Judge for Eastern District of Virginia. Mr. Ross is also licensed to practice in Virginia and the District of Columbia. Please join me in welcoming both our moderator, Nia Mills, and Riley Ross to our discussion. Nia, I will turn it over to you.
Thank you, Dean Isaacs. And thank you, Attorney Ross, for coming and speaking to all of us today. I just want to talk to you a little bit about the trial itself and the verdict. So if you could just walk us through what you were thinking, what would happen before the trial, during the trial, and then when the verdict came out, what were your emotions?
Well, first, let me say thank you for having me. This is a treat for me to be able to come in and speak about this important issue, and I really appreciated Dean Isaac's comments about, the impact of this case. So Nia, for starters, I guess the issue of just the charges themselves being brought, that was one issue of high anxiety, high stress. I've been practicing in the area of civil rights and criminal defense for, as I said, for over 20 years, and we do not see many cases of police officers being indicted and charged and held to account for abuses of their police powers and abuses of use of force. So the first question was whether or not he was going to even be charged, and that seems that's very problematic. It's troublesome because that we should even have to ask that question. But we've seen time and time again where officers have, at least the question of whether or not they should be found guilty for their actions aren't even addressed because they're not charged. And so unfortunately, that's the state of our system where that's the first question. And it's very troubling because we know that on the other side for civilians, especially civilians of color, that's often not an issue. Charging someone is not an issue, and then something that actually it's pretty easily done. There's a saying in the law that says that a prosecutor can indict a ham sandwich, and that's just because that speaks to how easy it is to indict someone for a crime, which an indictment just simply means to charge them and to bring them into court of law to find out if they're guilty or innocent. And it's easy to do because it doesn't take much in order to charge someone. It's just someone essentially making a claim under oath that a person is responsible for some type of violation of law. And with that being the bar, it's obvious why it's frustrating when officers who seems to have abused their authority, whether it's caught on tape or not, aren't even charged in order for our system to find out if they are guilty. So that was what happened at the beginning. Is Derek Chauvin going to be charged for what we saw on that video for almost 9 minutes of him kneeling on George Floyd's neck? So when the charges did come, I think that was a big relief to a lot of people. But for folks who do this work regularly, and even for anyone who follows it, we knew that it wasn't going to be the end of it. It was encouraging to see the state attorney's office get involved under Mr. Ellison, because there's always a concern about how close of a relationship a prosecutor's office has with their local police department, because they interact with them on a regular basis. Prosecutors are supposed to keep that distance between them and make sure that even though that they interact with them on a daily basis, that it's not influencing their work. But prosecutors are human, and sometimes that does get that line gets blurred. And I've had many cases where I did not trust the prosecutor's office to basically be tenacious and do what they should do in going after and investigating an officer for conduct that I'm alleging. And so I've asked that the state attorney's office get involved, and so in this case it was good to see, because it gave at least the appearance that maybe that fear would be removed with regards to how close the local prosecutor and the police are. So with them getting involved, that was something. And then we started to see something very unusual, which was at least in criminal cases, which was bringing in prosecutors from the private sector. So the prosecution team was made up of 4 lawyers, and 2 of them were not in the state attorney's office. And so I think one of the lead lawyers is a commercial litigation trial attorney, and so we started to see kind of this case was being treated differently. And I think that was one of the first early indications that I saw that made me think that this was going to be a little bit different. And I can keep going. I guess through the trial, I started to I was able to see well, let me back up, because then came the charges, right? The charges, what he was charged with, seemed to be appropriate. A lot of people were asking about first-degree murder, which Chauvin was not charged with. He was charged with second-degree murder, third-degree murder, and manslaughter. And first-degree murder to me didn't seem to fit because it required premeditation, and I think that would have been very hard to prove. To prove that this officer, essentially woke up that day, or at least when he encountered George Floyd, he had the intent, the premeditated intent to kill him. And there's not a fine line as to when that premeditation has to start. So I think that would have been tough to prove. And when we saw second-degree murder as being the next highest charge that was charged, that was a good sense. And then we get into the trial, and I want to pause here because I feel like I've been talking a lot. I want to make sure that you don't have any questions to throw in, or I can keep going. You just let me know.
You can keep going.
Okay. I'm a lawyer and I get paid to talk, so I can talk all day, and I sometimes have to remember to pause there. So the charges were what they were, and here's the important thing is that, even though this was a different scenario because it's a police officer, what the prosecutor has at his or her disposal are the laws that are already existing. So we have, trying to apply the actions of a police officer with laws that were essentially made for regular individuals. And so you had these 3 charges against them, and the question became, whether or not they would be able to prove them. And that was a lot of the discussion. You saw a lot of talk on the news about it. But they were the top charges that I thought that it could be proved with regards to murder. And then came the extraordinary thing with jury selection. It was a unique situation because you had a situation where George Floyd's death was causing or led to protests all around the world, not just the country. And obviously, Minnesota, people living in Minneapolis, Minnesota, were very aware of George Floyd being murdered. And we had protests. I'm in Philadelphia. We had many protests here in Philadelphia, violent confrontations of the police of abusing people in the streets here in Philly and all over the country. You had them in New York, LA, and then spreading out to the world. So the question became, can you find a jury that would be impartial, meaning a fair jury that wouldn't let everything that they saw relating to the protests or how they felt about George Floyd's murder? Could you find people that would not let that influence how they would perceive or any evidence that would come in during trial? And for a lawyer, that's always a question that we have. You want to have a defendant is entitled to a jury of his or her peers, and is entitled to an impartial jury, a fair jury. And so the focus then became, well, can there be a fair jury? And that led to a lot of people being given a jury questionnaire. I don't remember how many, but it was in the hundreds that were given this questionnaire, and the questionnaire was filled with questions trying to determine if they could be fair or not. And from that large group, they selected a jury of 12 individuals with 2 alternates. Actually, they had 3 alternates, just in case something went wrong and one juror had to be dismissed, they could be replaced with that alternate. Once the jury was selected, we never find out their names, and that's common. You don't find out the names of the jurors as the public, but you do get to learn a few things about them: their occupation, their gender, sometimes their age, and we started to get a picture of what the jury looked like. We knew that there were people of color on the jury. We knew that there was a balance of identifying men and women on the jury, and that became something that gave us a little bit of, at least gave me a little bit of comfort as well. I think that could be debated by people. I know I've gotten into discussions about whether or not people thought that jury makeup was good or not, but the jury selection was televised, and so we got to view that, and that made that a little different and exciting. And then the trial itself, I thought, was well done by the prosecution. I had my critiques on some parts of it. The defense, I had a lot of critiques on that, but I thought that the defense, that was really more of the belief that I had, that the defense really didn't have much of a defense to put forward. At the end of the day, it's, you show that video, and how do you explain that? And that, I think that created problems for the defense. And I had some problems with some of the tactics they used, but I thought that the defense attorney himself did a good job of at least presenting a picture of, David versus Goliath, in a sense, where it was just him versus, the four lawyers on the other side. I don't think that that was actually the case. I think he had a lot of help behind the scenes, but it was something that, as a defense attorney, you do try to, remind the jury that it's the state or the federal government or whoever is doing the prosecuting against one person. And, and then there started to be questions about whether or not Derek Chauvin would testify. And in court, a defendant in criminal court, a defendant never has to be forced to testify. He or she has the right not to testify. And if they don't testify, that cannot be used against them. So that became a question. And I really wondered if he was going to testify, because there were just some things that only he could explain. And ultimately, the decision was made that he not testify. I think ultimately it was probably a good decision by the defense. And then we had the verdict. And I think, like most people I talked to, at least, I was, even though I saw the prosecution put on a really good trial, I was still nervous when the verdict came out. So those are kind of my emotions going in and out up through the verdict, and some of the things that I felt as a lawyer.
Yeah, of course. Me too. I was before, I was kind of nervous. I didn't even know if he was going to be charged or not. And then like throughout the trial, all the like notes that were coming out on like social media about what the prosecution was arguing, what the defense was arguing, I was kind of like taken aback, because I was like, I don't know what's going to happen. And so even the day when the verdict came out, I was literally in my bed, like about to cry, because I was like, I don't know what's going on. Like, this is kind of scary. So then when it came out, I was actually kind of relieved. I was shocked because I didn't think it was going to happen, but I was glad that it did. And you answered my other question about the jury, because this was very like publicized. And so I know it'd be kind of hard to select a jury that was impartial. So it's just a lot of emotions going on. But all of this to say, what do you think made the George Floyd killing so different than the rest of like the police brutality killings that have been going on? Like, what made this one so different than the rest?
No, that's a great question. I think that I think it's a combination of a few things. One, obviously the video. I mean, it's so shocking on so many different levels. One, just exactly what it showed, right? Just the pure disregard for another person. Just to kneel on his neck for so long when it was not necessary, when he was not resisting. You heard the reaction from the people who were watching it, you didn't hear anyone, talking about, what he did was right or wrong. It was all just pleased. They were pleading with Chauvin to just give him an opportunity to breathe, to give George Floyd, just a chance to live. And then to actually see him go unconscious, that was very devastating. And I think that, anybody that saw it, and I know people who refused to watch it after hearing descriptions of it, it's something that stays with you. I know it stayed with me. And so just watching it just for what you saw, it was very striking. And then the realization, I think, of knowing, if you believe this, and I believe it, that had it not been for the video, this could have easily just been characterized as something that was his fault, that he just simply died in custody because he was resisting. And we know, and then when you realize that, and you realize that could be happening and is likely happening all over the country, it then becomes very devastating. So I think that, just actually seeing that disregard for life and someone actually dying at the hands of the police, these are people who are supposed to protect us, people who we give the authority to take lives and to arrest people, and we place a lot of trust in them. To see that violated in such a way, I think it was very devastating, and I think that it brought home to what people of color, in particular Black people, have been saying for hundreds and hundreds of years, that it was, that these types of things happen at the hand of the police, and I think you had a large portion of our population saying, "Oh wow, I didn't realize this," or "Oh, now I get it," or "Now I understand." And then coupled with the people who have been understanding and suffering this for a long time, that's why you saw so many people on the street. So I think it was a combination of a lot of things, and it was really in some respects it was a breaking point for a lot of people, and then for a lot of people it was a wake up call. It was like a light being turned on. So you had these many different groups kind of experiencing it differently, but all of them being moved to react because of it.
Yes, and I know you said it's a wake up call for some people and then a sigh of like relief. Um, do you feel like it's enough? Like, do you feel like what just happened is going to help us move forward um, in life? Or like, do you feel like there's still more that needs to be done to see like real change?
Well, I definitely think that there's more that needs to be done. Absolutely, but I think that this that already, his death has not been in vain, because what I'm seeing is not just people who took to the streets last summer, but I'm actually seeing that those things turning into action and demanding legislation. I know here in Philadelphia, it has led to the formation of a citizens police oversight commission that the city council put on as a referendum in November's election, this past November, when we had the presidential election, and the people of Philadelphia voted to establish this commission. And it's a commission that's different than any other that we had before, because it gives the people sitting on this commission more power to hold the police accountable by subpoenaing records and subpoenaing them to testify, things that commissions didn't have before. We've seen places like Colorado ban qualified immunity, which that's becoming very popular. For people who don't know, qualified immunity, it's essentially a defense that state actors, including police officers, can use when they are being sued civilly for they can use it to say they have immunity from being charged, because whatever it is they're being accused of doing, it wasn't clearly established that it was against the law to do. And the law of qualified immunity has really been used as a way to let police officers escape liability in civil court when you are harmed, or maybe you're killed by police and your family then sue that officer. They've been able to escape liability. So Colorado as a state has banned that. Maryland just passed a couple of bills that have all been towards police reform. They have gotten rid of what's called the Police Bill of Rights in that state, which give police some really unbelievable powers, and I can talk about them later if we need to. But they've also enacted a statewide use of force policy, because normally each police department kind of has their own policies of how they can use force. Well, now in Maryland, there's going to be one that's statewide. That means that everybody in the state can look it up and know that no matter where I am in Maryland, here are the policies that this officer is supposed to follow. And they also created if the officer violates that use of force policy and ends up killing or seriously hurting someone, they could be criminally prosecuted for 10 years. So like I said before, where you have what Chauvin was charged with, he was charged with 3 crimes that anyone in Minneapolis could be charged with. In Maryland, now you have, in addition to charging them with already the crimes like murder that they have on the books that anybody can be charged with, they now have this special crime for use of force that only apply to police. And I think that's special because you can measure it in light of being a police officer. The maximum that you can get for that violation is only 10 years. I think it should be higher. But again, you can charge them in connection with other charges that require that have a larger maximum. But I think it's really important to be able to charge them with specific things that only police officers deal with. So we're seeing his death lead to a lot of action. And I know that there are a lot of other places where there are proposals on the books right now. There are people that are trying to get things passed in their communities. And so, even now when people are asking me, what can I do to get involved? I say, just go local, because I guarantee you that there's already something that people are trying to do in your local area. Give them some help, because they need bodies and they need voices. And there's things that are happening in your area right now that you can get involved with.
Yeah, I'm trying to see if there's stuff in my area too in order to get involved. It's just more of trying to figure out who to talk to. So I understand. I'm looking in the chat, and to go back to you talking about the charges, someone asked, can you explain that he was charged with? They're still kind of confused on exactly what they were.
Yeah, so sure. So he was charged with the three charges. There was a charge for murder in the second degree, murder in the third degree, and then manslaughter. And murder in the second degree, it basically has a couple of different ways that you can prove it. And he was charged with what is basically, it's called unintentional murder, being committed during the course of committing another felony. So a lot of states have a rule where if you're committing one felony and someone dies while you're committing that felony, even if you didn't intend for them to die, you then are held responsible for that death. And that is what he was charged with here. So Chauvin was charged with, they were claiming that he was already committing one felony, and that felony was aggravated assault in the third degree. So what they're saying is that while he was assaulting George Floyd, he unintentionally caused George Floyd's death, but he was still the cause of it. And so the assault was kneeling on his neck for that long. So they were saying that was the felony. You shouldn't have stayed on his neck for that long. Most importantly, even after he went unconscious, there was no reason for you to be on his neck. And so that was an assault. And then while you were doing that assault, you caused his death. It doesn't have to mean that it was the only cause, and that became a big issue at trial. What was the cause? The kneeling on the neck, or was the cause because he was addicted to drugs, or was the cause because he had this enlarged heart, or was it some of these other things that the defense was trying to throw in there? It doesn't have to mean that was the only cause, but it had to be a significant contributing factor to his death. So that was the most serious charge that he was facing. That was had carried a maximum sentence of up to 45 years. And then you had murder in the third degree. Murder in the third degree basically said that Chauvin was acting recklessly and with what's called a depraved mind, which basically means no regard for life. And in having no regard for life and acting the way that he was acting, he caused George Floyd's death. And that carried with it a maximum of 25 years in prison. Actually, 25 years in prison. And then the third charge was manslaughter. Manslaughter was the least serious in of the three charges. And it said that rather than acting recklessly, you were acting negligently, which basically means just kind of you didn't have to have this depraved mind, but you were still behaving in a way that was negligent. And in doing that, you caused George Floyd's death. And that carried a maximum of 10 years. So they were able to charge all three. And in some states, they are, if you are found guilty of the highest one, you may not be found guilty of the less ones, because it's almost as if you did the largest one, then you probably also did the others. But in this case, those are called lesser and included offenses. And I don't want to get too far in the weeds on that, but these were really three separate charges, and that's why he was charged with all three. And the jury was asked to determine on all three whether or not he was guilty or innocent. So I hope that kind of clears it up for people about the three different charges.
Yes, I think it did. Someone else asked, is it possible he can get a new trial? And we were talking that his lawyer filed a motion for a new trial. So if that does happen, like, what are the next steps? Like, how will this go on?
Yeah, so his lawyer did just file a motion either last night or this morning. I think it was last night, for a new trial, and he's asking for a new trial on many different grounds. Claiming that the judge abused his discretion in making a lot of rulings, such as failing to sequester the jury for the whole trial, You may remember at the beginning that the defense had asked for a change of venue, meaning that they had the trial somewhere other than Minneapolis. The judge denied that, so he's asking that to be a basis. And these are all very common. When you lose a trial, you usually ask for a new trial, and actually sometimes some states it's required that you ask for a new trial before you can appeal. So it's not uncommon, and it doesn't mean anything that was special about this trial that he's filing it. So it doesn't, there's no indication that there's a reason to do it, but it's just something that is commonly done. And he's also asking on the basis that the jury itself was in fear of, and that's why they made the verdict. So he's asking them to undo the verdict, and a couple of other things that happened. And if it is granted, then there would be just that. There'll be a new trial, and the prosecution will have to decide if they want to try him again. I doubt that the judge, and so when you file a motion for a new trial, the judge that oversaw the trial will decide that motion. And I doubt that the judge will agree, because you're basically asking the judge to, decide that you were wrong. Hey, judge, can you decide that you were wrong when you first said that there shouldn't be a change of venue, or when you first said that the jury shouldn't be sequestered? The judge is probably going to say, no, I'm going to stand by my original decisions. And then if he does deny the motion, then the defense will then appeal that to the next higher court.
Okay, yeah, that makes sense. I realized that people normally do file like for new trials a lot, and I heard about the jury like being in fear. Can you talk a little bit more about that? Because I wasn't quite understanding what they meant by like the jury being in fear of like the people like rioting, or like what was it?
Well, so I'm gonna do something real quick, because we're in COVID time, so I'm doing this from home, and Amazon just knocked on my door. So I'm going to keep talking while I walk to my door and grab something here. Let me turn off my camera. This is I'm so sorry, but I live in Philly, and if I don't get this package off my front doorstep in a while, it's not going to be there. But so he filed the motion, and he hasn't filed what's called the brief to support the motion. So we don't know all of the reasons that. Oh, sorry about that. We don't know all of the reasons that he's claiming that the jury was in fear. He has to wait and file his brief to give all of his support for his claims. But what I would imagine is exactly what you said, that his claim is that his belief is that the jury was in fear, and maybe that their verdict was done out of fear that if they came back with a not guilty, then people would riot and the like. Here's the funny thing, though. When you file a motion for like a new trial, you basically have to throw in all your arguments. So some of your arguments may contradict each other. So although he's claiming that the jury was in fear of giving back a not guilty because of the public, he's also claiming that the jury can engage in misconduct. And essentially said, I think he's going to argue, like I said, we don't have the brief yet, but I think he's going to argue that the jury had it out for Chauvin from the beginning, and they were always going to convict him. So you have these conflicting theories, but that's kind of the law. That's what you have to do, because you have to give all of your arguments at once. So on the one hand, he's saying, they were in fear, and they wanting to invoke sympathy for the jury, but on the other hand, saying this jury was horrible and they were bad and they were after my client from the beginning, and they were intending to convict him no matter what, and so they never considered the evidence and the like. They also accused the prosecution of misconduct. They say that they tainted the jury by doing certain things, like one of the things they said, not preparing the witnesses adequately, not producing certain evidence and the like. So a lot of different things that they're arguing as a basis for the new trial.
Yeah, it seems the jury does have like a very, very important part in all of this. And I remember you saying that there was a jury questionnaire that was going around to make sure that like they were impartial. Was that just for this case, or is that like a common practice that happens all the time?
So it's common in the sense of usually the prospective jurors have to fill out some type of questionnaire in order to get a little bit of information about them. So jury selection, first of all, that's actually one of my favorite parts about trial. I really enjoy selecting the jury because I'm a psychology guy, and I really like trying to figure out, why people do what they do, or the thoughts, behind their actions. And so it gives me an opportunity to try to predict, okay, how's this jury gonna react, or how's this juror gonna react? And you're given some limited information, and that information comes through the questionnaires that you're given. In Philly, for instance, the questionnaires usually just include basic things like your age, your occupation, your spouse's age and occupation if you have one, and then a list of questions to find out whether or not there are any conflicts with you serving on the jury, such as if it's a criminal case, do you have any members of, are you a member of law enforcement? Or do you have any members of law enforcement in your family? Have you ever been convicted of a crime? Have you ever been, no, I take it back, not have you ever been convicted of a crime? Have you ever been the victim of a crime? Those kind of questions, so that once you get them in deciding to pick the jury, you can then ask follow-up questions in order to find out if that person can be impartial. That's always the goal, is to find out if that person can be impartial. So a common question would be, do you are you more likely to believe the testimony of a police officer over a regular person? And they may say yes, or they may say no. Some people who are trying to avoid jury duty know which questions to answer which way, so that they can be taken off of a jury. But even if they do answer yes, like for instance, let's say that the question is, are you an attorney? Sometimes you may not want an attorney on your jury pool, because you think that they're gonna, they think that they know the law, and they're gonna use their knowledge to influence the jury, and maybe follow what they believe instead of following the law that the judge gives them to follow. Even though they're an attorney, it doesn't automatically mean that they can't be a juror. So the judge may say, even though you're a criminal defense attorney, do you still think you can be impartial? And if that lawyer, prospective juror, says yes, then they're still eligible to be on the jury. Now, whether or not they get on it is up to the lawyers. Oftentimes the lawyers can strike them, and oftentimes will. Like I've lost my chance to serve on a jury. I can't imagine ever being on a jury where someone will know my background and decide to let me on a jury, because if one person believes that I'm going to be good for them, it's more than likely the other lawyer believes I'm not going to be good for them, and then so they're going to want to take me off the jury. But that's what you do. You find out whether or not you can be impartial. So the questionnaires aren't that unusual. In this situation, the questionnaire was very unusual because it was much longer than what we normally see, and it asked much more probing questions, because you really needed to get into specific details about this. Normally, you're not giving a jury a questionnaire beforehand that talks a lot about the case itself. You don't give that juror a lot of questions about that. Once you get those people in the courtroom and start questioning them specifically, and that's what a process called voir dire, then you can ask some questions about the case. You maybe tell them, this is a case about a robbery. Have any of you ever been a victim of a robbery? Or here are the lawyers in the case. Riley Ross and Nia Mills are the lawyers in the case. Have you ever know them? Are they your family members? Are they, you ever work with them? So you want to find out if there's a conflict, so that you can then decide if those people should be on the jury. That's usually just about the most specific that you get on a case. But in George Floyd's case, they got a lot more specific about it, just because everyone knew about what happened in the case.
Okay, so this was like a follow-up opinion question. So if you are on the prosecution, what is like a question that a jury member could answer that would make you be like, no, like you can't be on this jury?
So each side, and just as background, each lawyer, the defense and the prosecution, get what are called preemptory strikes. And that means that you can preempt and strike that person from the jury for a reason, or for no reason at all. It could be just, I don't like, the jacket that you wore, Nia, and so I don't think that they know. That kind of says it's a big bright red jacket, and that to me says, my gut's telling me that maybe you're more leaning towards the defense. I'm going to strike you because of that. And I can do that, and you will never know the reason that I'm doing it. It's just up to me. If I do it though, and all of a sudden I'm striking like every Black female from the pool, then that becomes a problem. And the other side can say, wait a minute, I'm going to challenge that. It's what's called a Batson challenge. You say, I think that they're striking. He's trying to get all Black women off the jury, and you can't do that. And then we get into a debate back and forth with the judge, and the judge makes a ruling on that. If the judge does decide that I'm doing that, I'm in trouble. That first of all, that's not good, because I'm losing my credibility with the jurors, because they're like, this guy is racist and sexist, and that's not going to be good for me or for whatever I'm trying to argue. And then so those people may be put back into the pool. But so I do have the ability to strike anyone for any reason. So back to your question, like, what could someone say if I'm the prosecution? Then if someone were to tell me that, I always believe what the police say, and I think that these people and Black Lives Matter are they're basically terrorists, and they are out to just destroy property, and they hate America and things like that, then that would definitely give me a reason to believe that that person is not going to be impartial, and is not going to listen to the evidence, and is only going to do what the defendant wants. On the other side, if I'm the defense counsel and someone comes in and says, yeah, I absolutely, I'm a member of Black Lives Matter. I protested at the George Floyd every chance I get. I believe that we should defund the police, and I believe that we should abolish the police. And I don't believe a word that the police say, and the like. Then that would give me a reason to say, okay, fine, you can't be on. Now, I should say this. I talked about these peremptory challenges. If someone was that explicit with on either side that, I hate Black Lives Matter or I hate the police, if they're that explicit, the judge actually will strike them for what's called for cause. So I wouldn't even have to use one of my because I have just a few peremptory challenges that I can use, peremptory strikes. I wouldn't even have to use one of mine because the judge will just strike them for cause. The judge will say, you know what, you're gone, and there's a reason for that. You just can't. I can tell you can't be partial. You can't be impartial. So I'm gonna just strike you, and you're gone. So I wouldn't even have to use one of my challenges if they were that explicit.
Okay, yeah, there's a lot that goes into jury selection.
Yeah, it's one of my favorites, like I said, because you have to do this on the fly usually. I mean, they had a long time to select their jury. That's not usually the case. This trial was very different in the sense of you just saw a lot of things that don't happen normally. And I can get into that later, a lot of things that, that bother me about that. But yeah, this process normally is very quick, and you got to be quick on your feet, and you got to be like, someone will say something, and you're trying to keep track of everyone and decide what did this person, I strike this person, because you only once you get to the 12 people in the box and the 2 alternates, then everybody else goes, and there may be like someone in the third row that you want, and it's just like, how can I strike all these people so I can get to that person in the third row, so I still have a seat for that person. And then maybe you get to that person in the third row, and then the other side strikes them. You're like, oh, I wanted that person on my jury. Now who else can I find that's going to be good? Who I think is going to be good for my side? It's a very chaotic, and I like chaos. So I think that's one of the reasons I really like the process so much.
Yeah. So okay. How do you think this case will assist in working on like police reforms and civil rights, like going forward?
So a lot of people, I've heard people say that, now that there's a guilty verdict, that means that, this is going to, serve as what's called precedent, or somehow, prevent, it's going to have an impact on other cases. It doesn't work like that directly, meaning that, what happens in the Minneapolis jury is not going to have any effect. It doesn't have any binding power on any criminal trials that happen, for instance, here in Philadelphia, or any other criminal trials really even in Minneapolis, unless the judge were to make some type of ruling and then write an opinion. And then that opinion, let's say that the asks for a new trial and it gets appealed. And then that appellate court writes an opinion saying, the judge was very correct in giving this certain jury instruction. That could have binding effect on future cases because it's proof that, okay, this jury instruction is okay to use. But beyond that, it's not going to have that binding effect for, courts in other places outside of Minneapolis or outside of Minnesota. But for a practical purpose, I think that it does have an effect in kind of giving people the belief and the hope that we can, hold police officers accountable. And you need that, in order to keep fighting this fight, you need that hope, you need that belief that things are going to change. It also, I think, puts a lot of pressure on prosecutors' office to at least justify why they won't bring charges against an officer in cases where they don't do that, or run the risk of being held accountable, especially if they're elected and being voted out of office. I think that in particular, what happened in the trial where the police officers and the chief of police took the stand and testified and said, this is not what we do. This is not how things are supposed to be done. In Minneapolis now, what they said on the stand can be held against them. So if I'm a civil rights lawyer in Minneapolis, I'm taking notes and I'm trying to get a copy of the transcript of what they said, because I can now use that against them. Because here's the thing, even though those officers said, and the chief of police said, that's not how we do things, here's what our policy is, and he violated those policies. This is my personal opinion. This is just me speaking as Riley Ross. But I think a lot of civil rights attorneys share this view. That's what it says on paper, but that's not how they practice it. I was very upset to hear the chief of police and those officers get up there and say this is, and really, kind of act like that this guy, Derek Chauvin, was an anomaly and throw him under the bus as if that's not the practice in that police department. You know how I know that's the practice in that police department? Because Derek Chauvin was a trainer. They promoted him up the ranks and they made him training. He had a trainee, he had a person who was just there a week on the job that was next to him that said a couple of times, should we turn him over? He knew what it said on the paper, but he was witnessing what was done in practice, what was done every day. So this trainee, this guy a week on the job, knew what it said on paper, but he was seeing firsthand what the practice was. And this was a trainer. This is someone who was training all the other officers. So for the chief of police and for those other officers, those lieutenants and those sergeants to get up there and say, that's not how we do things, I disagree. Derek Chauvin was proof of how they do things, because he was who they put out there to train others. And if you're a civil rights lawyer in that area, you're now going to hold them accountable, because now they cannot say that this is, we do it a little bit differently than what it says on paper. You can hold them accountable for it directly. And that is the epitome of the systematic problems that we have with policing in specifically, is that it's one thing on paper, but you as the chief of police and you as the supervisors, you're allowing the practice to be something different. Derek Chauvin had many complaints racked up against him. So why is he a trainer? It's because the practice is something different than what's on paper.
Yeah, it's like a practice what you preach kind of thing.
Right.
And so knowing that most people probably are thinking the same thing as you when the chief of police went and said all of that, do you think the police officers and all these people testifying against Derek Chauvin, do you feel like that helped the prosecution or the defense? Or do you feel like it was just kind of like what are we doing?
Well, it definitely helped the prosecution, because it showed, it put the spotlight on Derek Chauvin. There's always this balancing act that you have to do, looking at the individual defendant and versus the system. And I usually see it more so on the defense side. It's usually more so like, I've got an obligation to my client. There may be some other things that I want to attack about the system, but if I start arguing all these other things, it may hurt my client's chances of whatever it is that we're trying to do. And so I have to, I can't really go against the whole system. I gotta focus on my client, because my duty is to my client. So the prosecution, though, again, this is part of the systematic problems with it, is that by putting on those officers to say this is not how we do things, it perpetuated and it allowed these things to continue to happen, because you're not shining a light on the problems that the department itself has. But, is that, some would argue that's not the prosecutor's job. Some would argue that's my job as a civil rights attorney to do. But unfortunately, the law makes it very difficult for me to do, because it makes it very hard for me to put the whole system on trial unless I have specific proof of patterns and practices. I have to have proof that, that lieutenants and sergeants are allowing these things to happen, mainly that they're saying, okay, go out there and violate the policies we have written down. So you basically have to have a smoking gun in order to do that. But so the prosecutors, by putting them on, it helped perpetuate this belief that Derek Chauvin was just an anomaly, and what he did was just a unique thing, and that's not how we do things on a regular basis. When in fact, that is how they do things. At least there are a few officers who do things on a regular basis that way, and they don't get punished for doing it. Because obviously Derek Chauvin did not get punished; he was promoted instead.
Yeah, that makes sense. Okay, so it's 12:51. I have like one last question. I was having conversations in some of my classes after like the verdict came out. And I heard a lot of like my classmates say that they feel like this case can go all the way to the Supreme Court. What are your thoughts on that? And like if you feel like it would, why? If it wouldn't, why not?
I don't think that it would go all the way to the Supreme Court because, well, okay, let me just explain how it could make it to the Supreme Court. It would have to be some type of constitutional issue in this case, or at least it raises some issue where different courts have different views on the issue. It's less likely to go because it's not in federal court to begin with. So it has to go in state court, it has to go up to the Minnesota Supreme Court. And then it has to, if there's a reason to go past that, then it has to go through the federal ranks and then to get up to the Supreme Court. That would be the most, that would be I guess the most likely scenario that it would take. In order to do that, it would have to be some type of constitutional question that came up. And that would be something that came out of these things that are happening now where the defense appeals or asks for a new trial and it's denied. And then there's some issue that comes up. Like for instance, here's one issue that came up. You may remember that the gentleman, Maurice Hall, who was in the car with George Floyd, he was prohibited from testifying because he took the Fifth Amendment. He pled the Fifth. He said, I'm not going to testify because if I testify, something I say could be used against me. So I'm going to refuse to testify. Well, the defense asked the court to force him to testify. And the court said, no, I can't do that because he's going to take the Fifth. The court is right on that. The Supreme Court has said you can't force someone to testify if it's going to incriminate them. But the defense also said, well, if he's not going to testify, we want to have statements that he made to law enforcement read into the record. That may be more of a question, the judge denied it, but that may be an iffier question. So that could be something that, because it invokes the Fifth Amendment, which is a constitutional amendment, that could be something that could make its way up to the Supreme Court for the Supreme Court to decide, A, should he have been forced to testify, and B, if not, should his testimony been used? I still don't think that it's likely because I think that this is not an infrequent issue. This is something that happens in courts all the time where there's a co-defendant or someone who they want to have come in and testify, and that person says, no, I'm taking the Fifth, and that person's already given a statement and the court's decided how to use it. So there's probably already enough precedent and not enough prior cases out there to decide the issue. Whereas the Supreme Court's going to say that's already established. We don't need to weigh in on this because there's no dispute as to what the law is on this issue. But that is something that could go up there. I think overall, though, I didn't see anything that was so unusual in this case that would make its way to the Supreme Court. But a lot of times we don't really know what's possible until we get to the point where there's an appeal and the different sides start arguing out their theories. So once we see that, then we'll have a better sense of it's something that could eventually ever make it to the Supreme Court.
Yeah, I didn't think it would go that far either, but a lot of people in my class did. So I was just trying to see, like, is there a possibility or not? But
I think that really speaks to kind of the enormity of the situation and kind of how this was such a big deal to people, because people are like, well, this surely has to go to the Supreme Court because we're not used to seeing this and being something that we're so engaged with on a regular basis. But from the law side, a lot of the legal issues come up every day. They just don't often come up with a police officer actually being charged and held responsible for murdering someone. That's what's different.
Yeah. Okay, so like knowing about the case and everything that's going on and how it ended, do you can you talk about like the sentencing that's going to happen in June and like how that's going to play out?
Sure. So the sentencing, the way that it's done is I told you, the maximum that he could receive on each charge. So 45 years for murder in the second degree, 20 years or 25 years for murder in the third degree, and 10 years for manslaughter. The judge has some decisions to make. One, whatever sentence he gives on each one, should they run concurrent or consecutive? Consecutive means, you do all your time on the first one, and then you start doing all your time on the second one, and then you start doing, once that's done, then you start doing all your time on the third one. More than likely, whatever time he gives, he's going to run them concurrent, meaning that they all run at the same time. And then there comes a question of, well, how much time does he get on each charge? Well, what's happening now is that more than likely probation is compiling information about Derek Chauvin and about the charge itself, and putting all that information into what's called putting that information into a formula that spits out what's called a sentencing range. And the judge then can decide, and that range is based on, did Derek Chauvin have a criminal history? Were there any aggravating circumstances about the case, any special circumstances about the case that should make it be looked at differently than the last murder in the second degree conviction? Are there things about it that we should take into consideration to say it's not, it's actually better than the last, than normal murders in the second degree, or it's worse than normal murders in the second degree, normal in quotes? The prosecution's already decided, they've already announced to the judge that they're going to be seeking aggravated circumstances. They're going to say that this is the case that is worse than other murders in the second degree. Why? Well, they haven't, I don't think they presented their brief yet, but I imagine they're going to say it's worse because this involved a police officer who's in a position of trust and shouldn't have done this. This involved a police officer who, put his knee on his neck for almost 9 minutes and kept it there even for X number of minutes after he was unconscious. Those are aggravated circumstances, which would make that sentencing range come out higher. I think that the judge is going to sentence within that sentencing range, whatever it is on each charge. And then whatever that sentencing range is going to be dependent upon the facts of the case and whether or not the judge believes that there are aggravating circumstances. I think that the defense is going to put forth what are called mitigating circumstances, which means that the defense is going to argue that this is actually better than normal, quote unquote, normal murder in second degree cases. And they'll probably argue things like he was just following the policy. He was doing what he was instructed to do and how he was trained. He's never been in trouble before. Things like he doesn't have a criminal record, things like that. He'll try to argue as mitigating factors. I think that my prediction is that the aggravating circumstances the prosecutor is going to play out, that the judge will accept those, and he's going to have a higher sentencing guideline range. I don't know what that range is though, because I don't practice in Minnesota, so I don't know all the factors that they put into that. But before sentencing, I think that will be released to us, and we'll know what the range is, and then it'll be up to the judge whether or not to stay within that range, go to the higher end of that range, or go beyond that range and sentence them to the max that's allowable for each charge.
Okay, thank you for telling us about all of this in this conversation. It's 1:00 now, so we're gonna start the question and answer portion of our program. The first question in the chat is, if there's a new trial, what would you say to people who are angry and upset about it?
Well, I mean, my first gut is to say, yeah, you should be. I'm sure I will be. It will be a lot about, what's the basis for it. I don't see, the few things that I thought that the judge, that gave me questions about some of his rulings were all against the prosecution. So I don't know that there are going to be many things that would be a basis to give a new trial to the defense. So it would be interesting to see what the reason was, and so if there is a reason, I would have to say I would believe that I would disagree with it and would be upset. It also would be, and again, this is not me not knowing. Now, there's a great reason that comes up. Let's say that we find out that there was a juror who who had a run-in with Derek Chauvin and never revealed it. Had a vendetta against Derek Chauvin and never told us about it. And there's some proof of it. Like, he wrote he wrote on his Facebook page, or he wrote a letter to Derek Chauvin saying, I hate you and I'm going to spend the rest of my life trying to bring you down. Let's say something like that comes out and the juror never revealed that. Then yeah, that's a basis for a new trial. I mean, and that's something I wouldn't be upset of, because that's you can't have that. You can't have that and say that was a fair trial. That's something that juror deliberately tried to avoid coming out, and you can't have any faith that he or she was impartial in sitting on that jury. So I guess there are some things that can happen that would not make me upset. So it really would depend on the reason. But if there was a reason that I didn't find to be legitimate, then I would be upset. And the thing about it is that, we had this trial. Like I said, they brought in 4 lawyers to argue on the prosecution side. They had these great presentations and these great, demonstrations and graphs that they would put up there, and simulations that they would put up on the screen for the jurors to follow that. That's not happening in most of the cases where people like you and I are being charged every day. It's not given this much attention. It's not given this much care. There are people that are being convicted as we sit here right now for serious crimes like murder and rape and robbery, where the prosecution is done in a day. And the care and consideration is not given to make sure it's a fair trial for the defendant, to make sure that the witnesses are, vetted and it's clear that they're telling the truth. There's situations where defendants are being forced into taking guilty pleas because they feel like that if they were to try to prove that they were innocent, that they have so many charges against them that there's no way that they are going to take that risk of how many years that they're facing, even though that they believe that they're innocent and they want to try their case, but the prosecution has charged them with so many things that they have no choice. Now, I say all that, but there are likewise people who are being convicted right now who are definitely guilty of the crime that they're being charged with. But I just point this out to say that what we saw in the Derek Chauvin trial is not what we're seeing that is happening in courts around the country all the time. So people aren't getting the same breaks and the same opportunities that we see here. And so that's another reason to be frustrated, because there's a lot of places where this much care and consideration are not being given to the process and to the defendant.
Yeah, I kind of struggle with that question a lot, just because people have a right to be like angry and upset, especially if this does go to trial. So I think like validating their emotions is a really good start.
Yeah, absolutely. I agree.
Okay, so the next question, those were asked. So to move from the case to more so like police reform, I was wondering if you can explain the concept of like defunding the police, because I feel like the concept and the idea is very like misconstrued by people, and it's kind of like they're thinking of abolishing the police, and defunding the police is something different. So if you could just like explain the concept of it.
Yeah. So one, it's not universal what it means, right? And that creates a lot of confusion, because when people say, uh, uh, you know, defund the police, they mean that. They mean take all money from the police. The I think that the majority of the intent behind that phrase is meaning to reallocate the funds from the police. You go into places, and the police department in cities and counties, they have a budget that is usually oftentimes the largest of all, education, transportation, housing. Usually the budget is largest for the police. And so the argument behind the defunding the police in a lot of cases, and in the way that I use it, if I'm using those terms, is to reallocate the funds. the police don't need money for the upkeep of military vehicles and tanks. My belief is that they shouldn't have those. We should get rid of the militarization of the police. The police should not be responding to certain calls, mental health calls. That money should be allocated to mental health resources so that they can respond to those calls, so that we have places to take people who need mental health treatment and help. The money should be moved from the police to things like education and preventative services, so that there's not all these encounters or crime that's happening in the first place. So a lot of times that's what's being talked about, is not getting rid of the police completely. It's about reallocating the money, how much money goes towards police services. Let's start thinking, what do we need police to do? What do we want them doing? Some people are talking about getting rid of having police dealing with traffic stops, or at least certain traffic stops. If you are speeding, or you run a red light, or you do a certain violation, can't that be recorded? We have a lot of radar and cameras there. Can't you take a picture and send them a ticket, just like you do if you run a toll on a highway? Does it need to be a pullover and an encounter for a traffic violation, because that could lead to violent encounters? And I think that those things are right. I think that rethinking what we need police to do and what we want police to do is right. There is and I'm going to take this time to talk about why. And here's why. A lot of police are trained in what's called this warrior policing mentality, where they're trained to treat their job and as if they are going out to war, and to treat the places where they police as combat zones, and then to treat the people that they encounter who live in those combat zones as combatants. And so if that's the way that they're being trained, and with this warrior policing mentality, it creates this us versus them mentality. And it's not even that it creates it as it's under unconscious or subconscious. It's they're told, it's us versus them. Your goal is to go home that night, and by any means necessary. And that, I'm not saying that, they shouldn't, that the police protection and their safety shouldn't be taken into account. That it definitely should. But for the goal to be that it's us versus them, automatically creates a scenario where there is the likelihood of an adversary and adverse interactions. Where if I'm treating you, if I meet you and I'm like, I'm already walking up to you like it's us versus them, and you may be a danger to me, I'm going to have a different encounter with you than if I'm walking up to you with this guardian mindset, where like my goal is to protect you and to serve you. So I'm going to approach you a lot differently if my goal is to protect and serve you than if my goal is to make sure you don't harm me. And that's just natural. So then you take that warrior policing mentality and that us versus them mentality, and then you douse that mentality with what we know about systematic racism here in the country, and how we view particularly people of color, specifically Black people, and even more specifically even Black men. And this is a view that we have that's held by all people, regardless of your race and your color. Then you have the potential for very violent encounters with people of color, because you're now thinking that this person is a threat automatically. So whereas I may be approaching you and thinking that you may harm me, now if I see you and you look a certain way, I'm like, well, you are going to harm me. Now I have a very different mindset. Now I'm approaching you with my hand on my gun, or maybe with my gun out already, because I really believe that that's your intention, even though I know nothing about you other than what you look like. So you've got to get rid of all those things in order to, when you start talking about how, these encounters. And so when you talk about what do we want police to do, then maybe one way is that we need to minimize the encounters that the police are having. And that's why people are talking about, do police need to be making traffic stops? Should police be responding to these sort of calls? In Philadelphia, for instance, we have police that whenever there's construction going on, and that can be anything from building a skyscraper to changing a light bulb in the street lights, the police are through the union are designed to protect those to watch over those streets. I said protect, but that's even ridiculous to say. They basically are the ones who shut down the street instead of putting up some cones and regular guys in traffic vests. The police will sit there at the end of the street and make sure nobody goes down that street. Why do we need police to do that? If police are doing that, then they are, there's another chance for an encounter. So they're there and policing in that area. There's another chance for an encounter with people who are walking by doing whatever. They're given the ability to do stop and frisk. Stop and frisk means you can approach someone on your suspicion and stop them and ask them questions. Well, maybe we need to limit that because we're seeing that most of those encounters are being done on people of color. And the overwhelming majority of those encounters are not yielding any type of arrestable offenses. So not only are they profiling people and stopping people of color, disproportionately, it's not even working. It's not stopping crime. It's not preventing it to happen. Do we need to have them doing those things? So that's what we're talking about. At least that's what I'm talking about. That's I think what the majority of people are talking about to get rid of or to at least look into defunding the police, meaning reallocate the resources and start thinking differently about what we want police to do.
Yeah, I like how you spoke about the us versus them and then like the war mentality. I never thought of it like that because at least in like people of color, we have like this guard up whenever there is like a police encounter. And so I can see how like that works. So like my question would be like, from your perspective, like what's an effective way to enhance like the communication between like law enforcement and the Black community? I feel like there's a disconnect. So how do you think we could like enhance the communication and maybe like somehow be able to respect each other a little bit more?
Well, I mean, there's a lot of factors that go into that, and one of the reasons, and people will say it, and I saw it in the comments that someone said that they were what they are white. I would say they were white. They are white, and they've been the victim of police warfare, and that's absolutely true. And this is not a unique problem with just people of color, and that's why you start from the idea of even just warrior policing alone. Creating this us versus them mentality increases the chance that people are going to have these negative encounters with the police. Not all encounters for sure, and there are definitely officers who are going into it with a different mindset. But when the training is this is how you do it, then that's how they do it. Clear example with the guy who was just on the force in Minneapolis for a week, and he's seeing Derek Chauvin saying showing him this is how we do it, as opposed to this is what the books say. So when the practical training is, hey, this is what you do. It's in some places actually we found that it was actually written in the manuals about the warrior policing mentality. Not all places is it written down, but when they're doing the training, conducting the training, and especially when they're out on the beat, and they're saying, "Hey, it's us versus them. That this is how we do things." Then it becomes this thing where there's going to be negative encounters, regardless of there's more of a chance for negative encounters, regardless of race. But like I said, once you add in racism and how we view certain groups, then it becomes a bigger problem. And if we address that, and we can address it's almost like you lift all boats. A rising tide lifts all boats. So if you can address that one, then you're going to be able to address the other groups that are being negatively impacted as well, because we're trying to get rid of this mentality and deal with the racism component to it. How do you do that? In particular within communities of colors, I think you have to look at is there a need to over police these communities of colors, because we see that happening. Is there are officers is there a requirement that the officers that are policing those neighborhoods be from those neighborhoods, or at least have to live in that city, so that they have some ownership over what's going on, and don't look at it as if like I just come in to do my job and I leave. And do they have more of an opportunity to meet those people because they're living there when they're off duty? Do they have a guardian mindset instead of a warrior mentality? is, do they believe and are they being trained that their job is to protect and serve as opposed to, be the warrior and to gain control and to dominate instead. So and when you start taking away resources and saying like, we're not going to, invest in these militaristic tactics or weapons, when you start saying, we're going to put more money into having the police interact with like social workers and maybe go out and respond to calls with a social worker, then they're approaching these situations differently and getting to know people and talking to people, and maybe police aren't viewed as a danger as opposed to being viewed as a helper. It's going to take time. I often think personally that officers of color are going to be a big part of this because just as I'm giving a talk now, when I have panels, if it's more than one person, I try to argue for having an officer of color there because they can speak to what it's like to be a police officer and come from that perspective, because that is important. But also they can talk to the community about what it's like to be a police officer, but they can also talk to police officers about what it's like to be a person of color, because they don't always wear that uniform. And I've talked to many officers of color who endure the racism and the different treatment when they're not in uniform, and their voices, I think, can hopefully be a bridge to that, because oftentimes they either grew up in the community that they're policing or grew up in the city that they're policing or still live there, if there's not a requirement that they live there. And so that could be a bridge as well. But it's going to take a lot of work. It's not something that's going to happen overnight for sure, but the will has to be there. The desire has to be there.
Yeah, I agree. And especially having something so small as a person of color, as a police officer, or having somebody that's from your area that can just go a long way in helping out. So yeah, I have another question that someone else asked, and it basically says like, what constitutes as excusable police violence, and at what point does it turn into like excessive force?
Okay, so it's excusable police violence. That's a really good way to put it, because it still puts the focus on violence. And whoever wrote that is very good with language, because usually it's talked about in the way of use of force versus excessive force. And by saying use of force, you're ignoring the fact that it is still violence. It is still being able to harm someone. But for most departments, you have what's called a continuum, a use of force continuum. And that means that there is a progression. There is like this line that goes like this of what you are allowed to do, what type of force you're allowed to use on individuals. And usually that force has to be reasonable based on the totality of the circumstances, based on what's happening. What is that individual that you're using force on? What is he or she doing? And that dictates the amount of force that you're allowed to use. So you usually start off with like things like voice command. Like you can, arrive on the scene and say, "Come here," or use your voice to tell them to do something. If they don't respond to that, if they disobey that, then you can step it up to something else where you may be able to grab them or put your hand on them or put them in handcuffs and the like. And it keeps going up to where you may be able to use pepper spray based on how they're reacting, or your baton, your asp, which is one of those the expendable batons, like the metal ones, all the way up to deadly force, meaning you can use your gun and shoot to kill them. And that's usually based on how they are responding. I talked about the Maryland new bills that were coming out. Maryland's new statewide use of force policy replaces that reasonable person standard, or the reasonable totality of the circumstance standard, with what's called necessary and proportional standard. And that's a little different, because it says, wait a minute, you have to ask not if it's reasonable based on everything, but is it necessary? And is it proportional to what's being done? Like, is it necessary for you in order to effect the arrest? Is it necessary for you to mace the person, as opposed to simply tell the person to stop, or to calm down, or to place that person in handcuffs? So it's got to be proportional to what's happening, and that puts more of a focus on what the other individual is actually doing. For instance, someone running away, it's going to be hard to say it was necessary to shoot that person in the back, or even in a lot of cases, it may be whether or not it was reasonable to do so. Now, if that person's running away and has a gun, and is pointing it to someone that they're running away to or something like that, then that may be a different story, because it's not just, it's about, preventing them from harming someone else, harming themselves, or harming others. So that's the line. And that is something that we're always, when I'm bringing civil lawsuits, or even if the officer is charged with criminal offense of excessive force, that is exactly what's being debated. What was the acceptable use of force or the acceptable use of violence that person was authorized to give before it became excessive? And that line depends on the facts. And the thing is, because it depends on the facts, who's usually telling those facts? The police. Up until we started showing out with cameras and pulling our cameras out and videotaping it and requiring body cams, it was the police word, the officer's word against the person who was arrested. Well, if that person was shot and killed, then it's only the officer's word, and maybe some witnesses if there were any there. So those facts, we don't know what they are, and that's why the videotaping, the body cams, the dash cams have become relied on so heavily.
Yeah, I do think the media aspect has really changed a lot when it comes to police brutality and seeing what's actually going on and whatnot. We have about 3 minutes left. So I'm trying to see if anybody else in the chat has any more questions.
There was something someone brought up that I want to touch on just real quick, and that was about the police unions. And I maybe talked about it before, but that not every place has to deal with police unions. But I know here in Philadelphia and a lot of cities, police unions are very, very influential and a big part of the problem, because they have so much power that they can dictate what can and can't happen. So, for instance, in Philadelphia and in a lot of places, the police union they have a collective bargaining agreement with the city. And that means that both sides have sat down at the table and bargained over what can and can't happen. And one of the things that they bargained for here is that if there's any dispute about disciplining a police officer, it goes to an arbitrator. And the arbitration is made up of 3 judges, one arbitrator selected by the city, one arbitrator selected by the police union, and then one arbitrator that's kind of comes from this list that they both make up. Well, the arbitrator, who kind of is a time vote, usually kind of wants to stick around, and a lot of times is heavily influenced by the police union. And so if something happens where the chief of police, for instance, wants to fire someone, and then that person who gets fired disputes it and files a grievance, then that goes to the arbitrator, and the arbitrator decides what should happen. And we've had time and time again where if the chief of police wants to fire them, they end up getting their jobs back because it goes to arbitration. There are other things that are built into this thing where a police officers, for instance, their disciplinary record, where they rack up complaints, after a certain amount of time, they get to erase them as if they never happened before. There are also things that they bargain for that says if the police officer leaves and goes somewhere else, you don't have to tell the new police station any disciplinary records that they had here before. So there are a lot of problems with the police union that get in the way of real police reform for police departments that actually want to make reform. And we got to take some of that power away from the union in order to make that happen. And how you do that? How you do that is by going local, by pressuring your city council to do something about it, to take away a lot of the power from the police unions if that's happening in your area. And I advise you to look into it. And if you have a strong police union, that's a way to try to balance the powers, to take some of that power away from the union.
Yeah, for sure. I think that's it. I just want to thank you again for coming and talking to us. It was very informative and I really enjoyed it. I'm gonna give it back over to Ms. Grant. Thank you again.
Thank you so much, Nia. I enjoyed this too. Thank you.
Thank you. Thank you so much. And thank you everyone for joining us this afternoon and participating in, as Nia said, this informative and enlightening conversation with Attorney Riley Ross. I just want to say thank you again, Attorney Ross, for taking time out. You did not hesitate to join us. And again, we applaud you. We also want to applaud Nia for doing such a great job. And I put in the chat to her personally, we do see you as Attorney Mills someday, very soon. Great job. We also want to thank you, Attorney Ross O'Reilly, for also sharing with us that one of the ways that we can continue to be a part of this change is to get involved with our political officials, paying attention to what's happening in our local towns and with our political leaders as they too work to demand change and to also enact change as it relates to police reform, social justice reform, to the criminal justice system, etc. And again, as you said, there are legislation that's in progress and bills that are being processed. So we'll continue to pay attention. Again, thank you. And again, we look forward to you joining us here at UHeart another time. Again, Nia, thank you for being a great moderator. Thank you, everyone.
Thank you so much. Thanks, Nia. Thank you, Chris.
Thank
I really
you.
appreciated it.
Thank you.